Denis Sparas. Very warm welcome to Digital Markets Research Hub. It's a pleasure to seeing you, and we have a chance to discuss the issues related to implementation and functioning of the digital markets regime, new roto competition regime. You're one of the most senior enforcers in the area, and I wanted to use this opportunity to ask you maybe some technical questions about the new regime, because they are very driven and they interest many of stakeholders and kind of our echo chamber, but also maybe some broader normative questions as well. But the first one is related to the core platform services. And can you just please summarize to us that we know that X amount of companies of undertakings were designated, or their core platform services. But I wanted to hear it from you, who was designated. Maybe there were some borderline cases. I know some investigations are ongoing. What is the state of affairs as of 2024, please?
Sure. Well, first of all, thanks for inviting me, having me, and being willing to listen. Even in a new year about the Digital Markets Act is always very interesting. I'm slightly worried that you are calling me a senior person. Talks a little bit. I hope it doesn't talk only about my age. But jokes aside, if we move to the Digital Markets Act and the designation decisions that we had, as you know, on 5th of September 2023, which is quite some time ago, or at least it feels like a bit of a time ago, we had 6 designation decisions, which means, we designated 6 undertakings that are providing one or more of the core platform services within the meaning of the DMA as so-called gatekeepers. And these are Alphabet, Amazon, Apple, ByteDance, Meta, and Microsoft. Now, what the DMA does, it envisages that specific undertakings are designated as gatekeepers, but then it also envisages that you identify those core platform services for which these gatekeepers, or which in itself, constitute a gatekeeping core platform services. So on one side, we have six companies which have been designated as gatekeepers, the 6 I already mentioned, but those companies were designated as gatekeepers for 22 of so-called core platform services. Now, depending on the company, the number may differ. So for example, when we talk about ByteDance as a gatekeeper, it was one service for which they have been designated, that's TikTok, as an online social networking service. On the other side, you have companies that have been designated for more than one of the core platform services which they provide. For example, if you think about Apple, they have been designated for example, for their App Store, for Safari web browser, and for their iOS operating system. Or, for example, Meta has been designated for 2 of its, we call them number-independent interpersonal communication services, but, people will normally, call them messaging services, which are WhatsApp and Facebook Messenger, but then also for some other core platform services like, Facebook and Instagram as online social networking services, Facebook Marketplace, and their advertising service. And then if we come to, the company which has most of these designated core platform services, Alphabet, where we have quite several online intermediation services which have been designated, like Google Maps, Google Play, which is their App Store, Google Shopping, and then, Google Ads, Chrome as a web browser of Alphabet, Google Android as the operating system, and, Google Search, YouTube. So you can see that while we have designated 6 companies, we also identified, specific core platform services which individually meet the thresholds, and there the number is higher than 6. And this is just in a nutshell. Of course, if you have any more specific question, happy to take it, but just to land a little bit the outline and what has happened on the 5th of September. Maybe because you also alluded to the fact, what else? Indeed, it's worth recalling that what the DMA envisages, there is an obligation on the undertakings which provide these core platform services that if they meet the thresholds, they should notify, to the Commission that that's the case. Now, you may remember from the past that even though we designated 6 of these gatekeepers, we actually had 7 notifications in July, 3rd of July of the last year. The 7th one being Samsung for the Samsung internet browser, and their commission again issued a decision on 5th of September. But that decision essentially acknowledged that, at the time of notification, Samsung also provided arguments which exceptionally tried to prove that even though they meet the quantitative thresholds, they actually do not constitute a gatekeeper for that specific service, and commission following the assessment not kind of, but agreed with the arguments which have been put forward by Samsung, of course, going into the great level of details of assessment of the different arguments. And then maybe a third kind of pillar of that, notification process and what was happening at the beginning are the so-called market investigations, because again, we had certain core platform services where the quantitative thresholds have been met, but where, again, the companies concerned, and in this case, Microsoft and Apple, provided what we would consider sufficiently substantiated arguments, to open a market investigation to aim to establish whether, specific core platform services that meet the quantitative thresholds exceptionally do not constitute gatekeepers. And as you know, for Apple, that is about their messaging service, iMessage. And for Microsoft, this is about, Bing as their online search engine, Edge as their web browser, and the Microsoft advertising service. And then really the last, maybe the point that is worth flagging is not only the DMA does not only envisage that the gatekeepers may be those companies that meet the quantitative thresholds which are laid down in the DMA, but the commission may also, through the market investigation, which is a more of qualitative nature, more classical type of market investigations that you would normally conduct, also establish, following certain conditions, which are very clearly spelled out in the DMA, whether a specific company for a specific core platform service, even though if that service does not meet the quantitative thresholds, may nonetheless constitute a gatekeeping core platform service. And you will know that on 5th of September, we also opened this type of, more qualitative market investigation into iPad OS, which is Apple's operating system for tablets. And this is really, I would say, like in a nutshell, what has happened on 5th of September and where we currently stand. So we have 6 designation decisions. We have 4 ongoing market investigations based on rebuttals, and then we have 1 more, qualitative market investigation based on the criteria which are laid down in the DMA.
Thank you very much, Denis. And I remember during these 2 years of continuous discussions about the nitty-gritty or legal nitty-gritty of the act, there was always reference to shortage of, not shortage, but kind of efficient use of resources of the commission. And probably there is always kind of an opportunity to engage in this tailoring competition more actively, and it's terra incognita. We don't know how to tailor it, how to do pro-competition regime, if you use vocabulary of UK. And was it anticipated at the time, or when the commission was drafting the legislation for itself, that such parade of designation challenges would emerge immediately? I mean, designation challenges, but we can somehow imagine that in the future we will every procedural step is likely to be challenged by gatekeeper. Is it inevitable part of the game where so much is at stake? Is it something which could be avoided? Again, referring to the UK, maybe we in this island can learn something in terms of how to designate, how to ease the limited regulatory resources and to refocus them on more productive, creative aspects of the new regime.
Well, it's a very good question, but maybe, I would like to take it a little bit in a few steps, right? I mean, one thing I would really like to say, and I think that's very important to stress upfront, right, is the fact that when we talk about the DMA, we talk about the kind of ex ante regulatory tool, right? So I think it's very important to keep in mind that we are not talking about a classical competition law type of a tool, even though, in the how do you say, in the preparation of this legislative act, a lot of inspiration, of course, has been taken from competition law, you know, the investigations which have taken place and the outcomes of those investigations. But I mean, just to make it very clear, you know, that we are not really talking about any type of a competition law regime, right? Now, when it comes to the challenges, I mean, of course, you know, already at the time of kind of, you know, putting it together, you know, I mean, working on the proposal and then through the legislative process, I think some of the, let's say, challenges and points could have been anticipated, and we have probably anticipated, which means, you know, we have anticipated that there will be discussions about the delineations of the services, you know, what are the borderlines of those services, and not in the context, you know, of this classical, you know, because many of the listeners of this may be, you know, more competition law experts, not in the context of, you know, defining what are the boundaries of the relevant market, but more, you know, what are actually, where are the borderlines of different core platform services. And I think to some extent, this could have been expected, whether to the level of details, you know, that, you know, we actually saw then in the discussions before the actual notifications and during the process, I don't know. I mean, to be very frank, probably, you know, some of the details and some of the discussions which we have had probably were not expected to that level of details. Now, when you talk about the challenges, I think, you know, I think you kind of answered to your question in a way, right? I mean, this is part of the system which we have in place, right? So, of course, I mean, the DMA was, you know, proposed and adopted in almost, you know, same form as it was proposed, because, you know, I think not only we as a, you know, European Commission, as somebody that, you know, has the, you know, the task of proposing a specific legislation to address a specific problem which has been identified, but also the co-legislators, you know, felt that indeed there is an issue when it comes to the digital, you know, services, digital markets, however you want to call them, that, you know, urgently needs to be tackled. And this is an issue which I think, you know, if you think about not only the EU, but more globally, you know, like if you take, you use the example of UK, we can use example of Germany, we can use example of the US, Japan, you know, Australia. I mean, whichever, you know, jurisdiction you will take, you will see that very similar type of problems in the you know, online platform economy are being identified. And the DMA is simply trying to kind of tackle that issue. And there is a wide agreement that there are issues that need to be tackled. Now, there is agreement on this. Now, different jurisdictions, and that we can see, apply different, or how do you say that, take a different approach to try to address the issue, right? On one side, you have the EU with the DMA and more ex-ante regulatory type of instrument. On the other side, you have, as you said, you know, UK with more like kind of competition law type of a tool, right? Or, you know, something which is very close to, very, very close to competition law. Same, for example, Section 19A in Germany, which again will be very close to competition law. It's part of their Competition Law Act, right? Even though, you know, we talk about maybe more economic dependency type of provisions, right? So, I mean, what is important to keep in mind here, in our mind, is that we all agree on the problem definition and the fact that something needs to be done. Then how you approach this, you know, may be slightly different, and that may not also lead to, you know, how do you say that, challenges to the decisions which are being taken. I mean, I think the competition law examples show that even though there may be certain different approaches to things, you know, at the end of the day, a legal challenge to a decision or to a process is something which exists, is there, you know, to kind of, you know, allow for companies which are subject to these proceedings, you know, to test the premises that may have been used, you know, and the assessment that may have been done. And I don't think that this will that much depend on how the regime is being established, you know, and whether it's a bit more rigid or whether it's very, very flexible. You know, if I think about, I don't know, telecoms, for example, and electronic communications framework, right? It's quite close to what you would normally do in competition law, right? I mean, maybe in the past you have defined relevant markets, but you still had to define which services fall within that. And then you establish who has SMP, and then you kind of, you know, adopted remedies which were, adapted to the specific situations. And still, I mean, many, companies that have been designated as SMPs have challenged that, right? So the fact that, the regime may be considered or seen as a bit more flexible doesn't necessarily mean that, you will have less challenges. Could we have anticipated some of the challenges? I mean, it's part of the system, as you said, right? I mean, many companies, well, they feel that, either they have not been heard or they feel that, they have very good arguments going against the decision that has been taken, they will challenge that. And I think it's just part of a normal process. We, as the Commission, we do believe in our decisions very firmly. We have put all the arguments in these decisions and, we will defend our decisions, and we are defending them in front of the court. But this is part of the system, and it's a valid part of the system. I think it's good that we have this possibility that decisions can be challenged, and the premises can be tested again.
And as a follow-up question, we know that the president of the General Court of the European Union, Mark van der Woude, had called the DMA a lawyer's paradise. So, and I think it was even done before the final version was adopted, or maybe I'm wrong on this specific part, but before the machinery started working. So anticipating that, basically confirming what you have said, whatever the formula you design, however flexible, pro enforcement it is, still the very nature of law is open to problematizing the most innocent, trivial prima facie elements, and this is part of the game. But where, more pragmatically, where do you, using your crystal ball gazing toolkit, where do you anticipate the next phase of most proactive response by designated gatekeepers, or maybe third parties?
I mean, this is really, I mean, a crystal ball, which is very difficult to anticipate, right? I mean, first of all, I mean, one would hope that, when we talk about the DMA, everything will be fine. And, on 7th of March, we will be able to talk about, more or less effective compliance with the DMA, and no need for, much of a further investigation. Now, of course, this best case scenario is not always something which will necessarily happen, so one cannot exclude, and this can be seen in the sister act of the DMA, which is the DSA, right, where you see that even after designations there are issues which appear in terms of effective compliance, and where questions may arise. And of course you will have then investigatory powers which you will have to use in order to obtain all the information that you may need in order to be able to run a case, if there is a need to have a proper investigation. Or you may even need to use your enforcement measures in order to ensure effective compliance, because your investigation would essentially show that there is a failure to comply with any of the obligations by any of the gatekeeper for any of the 22 core platform services that I talked about, right? I mean, talking about which of these we can anticipate, I really think it would be just pure speculation. I don't think, I mean, you will appreciate, even before the designations, we already kind of started this process of pre-discussions with the potential gatekeepers at the time of the compliance measures, because many of the things that have to be implemented do require some lead time to be implemented in practice. I mean, you can imagine that after designations all this process has intensified. There are discussions ongoing, but I mean, even in view of the ongoing discussions, it is very difficult to say this will be an issue where the Commission will need to intervene with opening proceedings, investigating whether there is a non-compliance, or maybe even adopting an enforcement measure. But I mean, one thing sure, if we see that there is simply lack of willingness to comply, and then also clearly established non-compliance, I mean, we will not shy away from using the powers which the legislators gave us, both in terms of investigatory powers and also enforcement powers. And again, just to make a parallel to the DSA world, right? I mean, you have probably read that recently, at the end of last year, the Commission has opened its first formal investigation into a possible non-compliance by one of the designated very large online platforms. So again, just to to confirm that we take these acts very, very seriously and the effective compliance with them even more.
Speaking of the DSA, I know you've been you've been working in the legal service, commission legal services, but also you've been delegated to this pan-national team, dream team from DG Connect. So you understand, and which is kind of the place where the DSA has been created. Do you think it's a shortcoming, or I know the formal answer to this question, that it addresses slightly or significantly different set of issues, but the fact that very large online platforms and very large online search engines, the standards are lower than gatekeepers in terms of thresholds, and thus, if we take seriously the potential hypothetical opportunity to facilitate new horizontal entry for potential challengers of the status quo, the company, the challenger would be designated under DSA before it will become designated under DMA, and thus receive this regulatory burden maybe a little bit too earlier. Were there objective reasons for making the threshold lower in terms of implications for the DMA regime, or is it something which has rather marginal implication or maybe non-implications at all? How, and maybe more broader, how these two regimes interact in real life in your view?
I mean, for me, one would really need to go to the basics of both facts, right? I mean, if you think about the DSA and DMA, I mean, no doubt they are in a way, two sides of the same coin. Having said that, they do pursue slightly different objectives, to say the least, right? On one side, you have the Digital Services Act, which really tries to tackle some societal problems, right? If you think about the online environment, and the fact what we can access or what we are exposed to on a daily basis, what you try to ensure is that users who are bombarded with the tremendous amount of information remain safe, and their fundamental rights in the online world are equally protected, right? And I think when it comes to the DSA, it's a lot about the nature, the size, the reach of the service. And once you are, let's say, once your reach is really significant, which or you kind of become a systemic platform, like some of the designated very large online platforms are, there is this it becomes very important that the way you design your service essentially ensures that users of your service are adequately protected. And this is not to say that that doesn't apply to other online platforms or some other providers. The thing is that because of the again, the size, the reach, the nature of the services that they provide, you need to have in place a specific system which addresses the more societal problems. And as similarly to the DMA logic, DSA is also kind of introducing a systemic of asymmetric obligations, right? So bigger you are, wider your reach is, more important you are for the society, the obligations which are, that you need to comply with are broader. And this is not about the regulatory burden. This is really about, any responsible company in the world, will try to ensure that its users are, safe, and that the way they use their service is, in the safest possible way. So this is more about the societal challenges that have been identified, and let's be also clear. I mean, if you think about the horizontal regulation of the online environment, of course, there are many rules in between the e-commerce directive from 2000 and the DSA, which was, kind of came to life in 2022, if you want like that, right? Adopted a bit before, but not much was happening, So in terms of regulation, it was a lot about the self-regulatory environment, and kind of like this voluntary, addressing the problems. And it was clearly established that it's just not sufficient, that you need to bring in certain intervention. And again, this intervention should really be to the extent necessary, right? On the other side, you have DMA, and this is yes, of course, it's in a wider context, it is a societal issue, but it's more about economic challenges that you have, the fact that we as users, may be treated unfairly when we are using some of these online services, and then the business users of these, platforms, may not have the equal opportunities because, you know, I don't know, some markets may have tipped, you know, because, you know, again, the nature of the services and the reach and the size, you know, allow them to behave essentially quite independently from anyone on the market, right? And therefore, you know, in order for you to have, and now whether you want to call it competitive, you know, what many people from more competition, you know, law type of world would call it, or contestability, you know, which is, you know, the objective of the DMA. But just to, you know, to say that the idea is that you ensure open, you know, services, open markets, you know, where there is fair, let's say, competition, competitive process on the market, and, you know, where users have the choice, you know, also through the empowerment which the DMA provides for them, and that there are equal opportunities for everyone on the market, right? So I think, again, you know, the two complement each other, but because they have a slightly different objectives, and because, you know, the issues that you're trying to address, you know, you cannot have exactly the same, how do you say, the thresholds where you intervene. And if you think about the reach as such, right, the threshold is the same, which is essentially 45 million either users of the service, if you want to call them that way, or recipients of the service in the DSA. But then when it comes to some other aspects, you know, like importance for the internal market, which is very important for the DMA, also for the DSA, but that is kind of embedded already in the 45 million as well. But then the entrenched position, which is very important for contestability, you know. So that's why in the DMA, you may have certain additional, you know, how do you say that criteria, but that doesn't mean that, you know, you are making a huge difference between the two regimes. You're always against systemic players in the market, which are very, very important, you know, either in view of societal importance or in view of the economic importance.
You mentioned objectives, Dennis, and we know the kind of textbook answer to this question, and we also know that, you know, we can engage in legal casuistics as well, trying to scrutinize the differences and similarities of competition, sensu stricto, contestability, fairness, and we can call it sui generis competition law. Some people have the standing, or most of us actually, in competition sector. But I wanted to ask you a question more related to your personal vision about what do we want to achieve. It's like we know the ingredients, and we hear that it's almost automatized, self-executing mechanism. But we all understand that, like a good chef can create very different courses with the same identical ingredients. In the same way, you as enforcers, by giving your preferences to some aspects of obligations, particularly of Article 6 and 7, and others, you can channel the functioning of the new regime. What would be your polar star? What would be your navigators in this very delicate and very, you know, problematic in functioning of the new regime, where so many factors will be somehow trying to influence the clarity of your vision?
I mean, so I think it's very difficult at this point in time to talk about, you know, prioritization of something, right? I mean, you know, the way the system is built is, you know, you designate the gatekeepers, you know, they have to comply with certain obligations, and those obligations have been identified because there were issues and problems which have been identified in those areas in relation to that behavior by those specific types of companies, right? I mean, as I already mentioned, DMA is only about the gatekeepers. It's not about any provider of online intermediation service, you know, that may, you know, engage in this type of behavior, but it's really about the, you know, the gatekeepers. So at this point in time, you know, we are really working towards effective compliance with all the obligations, right? Now, of course, it's probably fair to say that some of the obligations are fairly straightforward, and where, you know, one would hope that, you know, in terms of prioritization, there wouldn't be that question, because, you know, because of the clarity of the rule, you know, one would expect there shouldn't be any question of compliance or non-compliance. And one would also expect that there will be a clear compliance. Let me take a very clear, I hope, example, right? Article 5.6, it essentially says to gatekeeper, you cannot prevent your business user, to complain about the behavior which they may find, in a way non-compliant with the DMA. Now, I would really hope that there should be no question what the gatekeepers have to do in this case, right? On the other side, there may be situations where certain provisions do require either there may be some interpretation questions, or where the gatekeepers may have different ways how they feel that they can comply with the obligations, and where the discussion may be which is the most effective, or which is still the effective way of compliance. And there we have this, as I said, up until the 7th of March, which is kind of the deadline for where they have to comply, we are in these so-called pre-compliance discussions to try to see with them, for those instances, what the potential, solutions could be, address any interpretation questions. And again, this is not the process only between us and them, the gate, so between the commission as enforcer and the gatekeepers, but also, we are very clear that we feel that this is a type of a work where also the views of the stakeholders, the third parties, being the interested third parties, because they may be beneficiaries of the obligations, or I don't know, consumer associations, or even what any business associations may have interest and may say something about these things. We have organized the workshops. We are also thinking about other ways of obtaining information from the third parties. We have bilateral meetings with these third parties. We have multilateral meetings. So again, the importance here is that we get the best possible feedback which can inform the future compliance discussions in view of the compliance deadline. But of course, let's also be very clear. 7th of March is not like this, big bang date where, all of a sudden, things will be fundamentally different. Of course, we will see many changes, and we expect to see many changes, to the benefit of both end users and business users. But there is probably no doubt in anyone's mind that, the experience may show that certain things which maybe even today we feel, not only us as enforcer, but also stakeholders, that okay, it seems as a effective compliance solution, may actually be seen, as it is put in practice, as something which doesn't actually deliver the results which one would have want to see. And the DMA specifically envisaged the possibility that if the compliance measures which have been implemented are not effective, that we can think about modifications of those compliance measures. So I think many people, especially those that comes from a more ex-ante regulatory environment, often say, it's very difficult to get it right the first time around, right? I remember some people in BEREC, having a lot of experience from telecom ex-ante regulation, saying like, it required a couple of rounds of market investigations, to come to, maybe the most effective compliance solution. But we have seen in the developments of electronic communications framework that, if you think about how the regulation looked like in 2002 and how it looks today, things have moved quite significantly. If you think about markets that have been susceptible for ex-ante regulation in 2002 and the ones which are susceptible for ex-ante regulation today, you see that many of them, are being considered as competitive markets where the ex-ante intervention may not be justified. So, one would hope that the type of behavior which is kind of, prescribed for the gatekeepers is something which will become new normal, and, you will not have to prescribe it because it will just be part of a normal, behavior by these companies on the market.
And this leads me perfectly to the question, which I decided to divide into two parts, if possible. Regulatory dialogue, but the first dimension is regulatory dialogue with designated undertakings. Many authoritative voices say that if we have many enforcement actions, it will be an indication of failure, actually, because the regulatory toolkit presupposes continuous regulatory dialogue, even if it's, if you have some occasional litigation, of course, it doesn't diminish, it's not kind of, it doesn't change the relationship into kind of hostile mode. Yeah, it's continuous work in progress. Do you think you have sufficient toolkit for calibrating the nuances of all these obligations? And maybe one of the examples is the mechanism of commitment, which has been proposed by the Commission, but then reduced in course of the co-legislative process to only the issues of systematic non-compliance. Do you have sufficient tools which are compatible in terms of allowing you to make the first movement in terms of proposing what precisely would you expect the company to do?
I think, I mean, I think your question has quite many dimensions, right? I think what is important to keep in mind, indeed, that again, this is not competition law, right? And one important, how to say, conceptual difference, and where many people coming into this area from more competition law world, I think had or still have difficulties is, it's a very different environment, right? I mean, it's not about, the enforcer going off to you because, you're not complying or because you're potentially breaching a set of rules. Here it's more about the premises that, there is a set of rules that you will, comply with, you will have to show the compliance with, and this is our premise, right? And in order to achieve that objective, of course, there will be a constant, and this is the big difference. It's quite an important difference to a classical competition law world, right? In an ex-ante regulatory environment, there is a constant ongoing dialogue with the regulated entity, with the stakeholders, through various means. And the objective here is, to have that ongoing dialogue because, it's important to identify any shortcomings in the compliance, solutions as early as possible. And again, the purpose is not to identify those to, apply the enforcement mechanism, and start imposing fines. I mean, rather to the contrary, the objective is to identify the problem as early as possible and also address it as early as possible. I mean, again, I'm not saying that, down the line, you may not need to use also the enforcement measures because, I mean, maybe the compliance is not something which comes naturally, or, there may be fundamental disagreement on how the compliance measures should look like, right? So I think that's important to keep in mind as a starting point. The ongoing, regulatory dialogue is something which I think it is an important, fundamental principle of the DMA, right? And that's why DMA is a more classical ex-ante regulatory instrument, Then, of course, the next issue is, about, whether we have, as you said, the necessary tools, the necessary framework. And frankly, I mean, yes, I would say so. I mean, there are many different tools to allow us, first to have a dialogue, which can be informal and formal. There are also tools which allow us, to, how do you say, to adapt the compliance measures where it's shown that they are not effective. I already talked about the fact that if we identify that certain compliance measures do not deliver, do not ensure effective compliance, that we still see issues, we can, kind of open formal proceedings and see through those proceedings, what could be the, let's say, the modalities that we need to change, what could be the mitigating measures. Of course, again, there was a lot of discussion at the beginning, in the preparation of the DMA, and then when the proposal came out and also in the adoption, a DMA is very, very static, And I really feel that this is one of the myths around the DMA, right? I mean, the DMA itself provides for tools where you can update both the obligations and where you can also update, the core platform services. Now, of course, for that, you need to go through the market investigation. You need to identify whether there is a specific behavior, that may need to be addressed. But it's not only about, like a classical way to do these things, through the new legislative proposal. I mean, we also have the possibility of a delegated act where we would, for example, establish, okay, today, a specific obligation applies only to some of the core platform services, but we also see that the issues which are being addressed with the specific obligation arise in relation to a core platform service which is currently not addressed by the behavior, right? By the obligation. We can, through the delegated act, modify that. I mean, the legislator, very clearly circumscribed those delegated powers to the commission, but still they exist. So I really think, that the DMA provides for those tools where, the ongoing constant regulatory dialogue, the possibility to kind of reopen the, already implementing compliance measures because they simply are identified as ineffective, as well as, the possibility to adapt the obligations, to adapt the core platform services. I really think that if you think about the life cycle, the DMA provides for the tools which allow for this very dynamic, adaptations. Now, is this exactly the same as in some other jurisdiction? As you may again, have seen in some other areas? Well, probably not. It's not, I mean, the DMA is not built in a system where, you would identify who is the gatekeeper. You would designate that, for example, through the market investigation, not even through the quality, through meeting the quantitative thresholds. And then not just simply apply the clearly defined obligations, but, from the toolbox of remedies, start, modulating those remedies to a specific situation. That's not what the DMA does directly, but it provides for the tools where you can achieve the same result, right? So if you think about it, yes, there are conceptual differences in different, how do you say that, ways how you can do this. And, you already referred to the UK and the way they do it slightly differently, but it does provide for the tools which essentially, will achieve the same results. It's just through different means, right?
And another dimension of the regulatory dialogue is communication with third parties. And here I know it's probably less question, it's more like a compliment to the Commission, who, in my view, managed to pass through this very delicate way between Scylla and Charybdis. On one hand, not formally given status of third parties' legitimate interest, as one of the versions of the DMA had, I think, in the Parliament. On the other hand, however, you are very open with organizing these amazing stakeholder workshops, and so you are open to hear third parties who can communicate, who know best the situation in the market, who can identify problems and channel you to the right way. So how do you envisage this? First of all, maybe you can explain why some people would say that it can be instrumentalized and used excessively, maybe to create a flood of information, bombarding you with maybe unnecessary or maybe very complicated messages. And thus, this pitfall has been avoided. And yet, on the other hand, the Commission is very open to hear what's going on and to learn itself in order to adapt quickly to the situation.
Yeah, I mean, one thing I can just reiterate what I think you already said, right? I mean, the mere fact that it was not featuring in the Commission proposal and also not in the final, legal text of the DMA, the fact that you would have a formal complaints process, formal complainant status, and, all the procedural safeguards around it, by no means mean that we are not open to hear what the stakeholders have to say. If you think, for just one example, which I think very clearly shows that we are more than not just willing but open and inviting the input from stakeholders, is the obligation of a compliance report. If you think about it, it is an obligation on the gatekeeper, but it has two components. One is, of course, to the enforcement authority to see how what kind of compliance measures have been put forward, or implemented, so that the compliance with the DMA is ensured. But the other component is also what we would call public version of that compliance report, where all stakeholders, interested stakeholders, will actually see. And for us, that public version, of the compliance report will have to be sufficiently detailed and granular, to provide meaningful information to third parties so that they can, provide their own views and inputs about the compliance measures, right? And we are actually very keen to obtain that information and feedback from the third parties. So that's one aspect where, it's very clear, yes, there is no formal process of, kind of collecting that and, inviting that and having a formal status of something. But at the same time, it's something which is very important for us to obtain that feedback, right? As you said, in case of workshops, I mean, we also are seeking this feedback, either facilitating, through inviting people to come to us, or, many stakeholders will come to us in any case proactively, to try to provide us with the information about what they feel and think about the compliance measures which are being put forward, and thought about by the gatekeepers. And, third point, which I also want to say, for us in these pre-compliance discussions with the gatekeepers, we very often and very clearly communicate that we expect that any compliance measures which are being considered are also, and now I don't want to, I would use that word in inverted commas, like, test all their thoughts and all their compliance measures with the third parties, with the interested stakeholders, so that they obtain this feedback, because this is the feedback which we will ourselves seek, to see how the third parties, which are essentially users of the service, feel about the measures which are being put forward, and whether those measures which are considered will actually, effectively achieve those results. Maybe just as a final point on this, there was a lot of discussion whether, people should have a complainant status under the DMA. I mean, it was filed by us when proposing the DMA, but also by the co-legislators, even though, as you said, in some of the reports of the committees in the European Parliament, there were some ideas of having that formal status. It was felt that, this can take away a lot of resources, energy, and focus from the issues, right? So we are not saying we are not listening and we don't want, we are not inviting your feedback. But what we are saying is we want to have, sufficient resources and, how do you say, the capability to get that input and to use it to the, to the best of the effective proceedings, right? I mean, I mean, we also, I mean, the DMA is a EU law, EU legal act. We have to provide the reports on the implementation of the DMA. I mean, it's not completely excluded. It cannot be excluded that, the experience will show that maybe, more formal status would be necessary. But at this point in time, and, this was confirmed by many people, having experience in specific areas where more formal complainant status do exist, that indeed, the approach where, input is invited, and not at all, kind of, pushed away, but where, you don't have very formalized procedures, which can, really occupy a lot of resources and time, is probably the best balance at this point in time, right? So, but I mean, by all means, as you said yourself, we are very much open and inviting any feedback.
By the way, in the UK, broad equivalent, I think it was 6 or 7 stages where the CMA, before conducting any formal step, have to do public consultation, which I find quite potentially challenging. A more difficult question, maybe, Denis, if you still have time, about anti-circumvention. I know that. So where did you take the inspiration from? We have it in foreign subsidies regulation. We have it in common foreign security policy. It's quite a peculiar species. So from one side of legal mind might say, well, if you formally comply with the letter of law, you cannot be found in non-compliance with the spirit or anticipation of law. Others understand that there is 1,001 way to for those who are native speakers in this digital chaos or universe to tick all the boxes without delivering what is expected to deliver. So the choice is hard. But how do you see this mechanism in practice? And did you take the inspiration from other areas of EU law?
I mean, you can imagine that, when one is thinking about the issues which you may be facing, right? I mean, you are trying to take inspiration in solutions that may already exist and that, may prove effective or non-effective. Because you know, you can imagine you can learn from both, right? I mean, something which actually works in practice, but also something which doesn't work in practice, or which is a bit more challenging in practice. And, the fact, I mean, you refer to, to the issue that, it may be legally, I mean, it may be procedurally very challenging if you have too many steps where you need to formally consult, right? This was also a bit of a, thinking on our side. It may be, quite challenging, and, may lead to unnecessary delays, which may undermine of the objectives of the DMA if we have, very formalized procedure for complaints, which may, just again take away the resources and time we need for something else. So when it comes to, the anti-circumvention provision, again, the thinking was, okay, we have obligations which are laid down, right? But there are different ways how, I mean, the experience shows, unfortunately or fortunately, I don't know, that even if you have very clear obligations, people will find innovative ways how not to comply with them, right? I mean, especially if there is interest for not complying with them. And what we wanted to ensure is, it's very clear from the DMA, if you think about Article 8, if you also think about Article 13, the obligation is on the gatekeepers to ensure effective compliance and also show that effective compliance. But we also kind of, anticipated for a scenario where, maybe, there may be other ways, technical nature, commercial nature, contractual, whatever that may achieve the same result as non-compliance with the specific obligation, but that may take a different form, right? Or, be implemented in a different way. So we were really thinking like, okay, we need to have, kind of a tool that we can use so that, if we get into this, more innovative, sophisticated ways of not complying with the obligations, that, we still have a tool which allows us to intervene in those situations and, question that type of behavior, which may not neatly fit into a specific conduct that is captured by the obligation or prohibition, but which may still achieve the same result. Let's take example of Article 5.3 and, the discussion about parity clauses, right? And, ban on parity clauses. I mean, that provision already very clearly says, what you are not allowed to do is, to require someone, to offer you the same conditions, or also to implement, measures with equivalent effect. So if you think about that specific provision, it already embedded this idea that you have in the anti-circumvention clause in the provision itself. But, we couldn't do that everywhere. It's just that in that case, the experience already showed that we have seen certain other behaviors which were achieving the same result, but didn't look exactly the same, right? So here it was really felt, okay, we need something like this, which allows us, to intervene in those cases where, again, companies would come up with some other ways of undermining the compliance with the obligations, right? And again, that's why you also have this quite broad clause capturing, any technical, contractual, commercial ways of doing so.
And if I may ask, moving to the closer to the end of our conversation, I wouldn't ask for 24 hours with Denis Sparas, but maybe 8 hours with Denis Sparas. Can you maybe visualize to us how the work on the DMA is doing on daily routine? How do you communicate? How often do you meet? How large the consensus is between the different members of the team? Is there any invisible line between DigiCom, DNA, and DigiConnect kind of vision philosophy? And maybe you can also tell us finally who was the one who designed. Was it one person who designed the name of Article 6 of the DMA with this very elegant formula?
So to start at the end, I don't think there was one single person. I think, again, I really have to say that, both the preparation of the DMA, the negotiation of the DMA, and now all the work on the implementation and enforcement of the DMA is really a joint project, right? And it's an effort of the team, and it's effort of a large team which consists, as I think you alluded to, and I'm sure again listeners are very well aware of. But contrary to in the commission, normally there is always a lead service which is responsible for a certain file, which is in case of the DMA. Kind of there is a lead service, but the lead service is called the DMA team, and it consists of people from two different services of the commission, as you said, colleagues in DG Comp and colleagues in DG Connect. And I have to say, besides the fact that we sit in two different buildings most of the time when we don't have meetings, I mean, we do work as one seamless team, and I mean, if you talk to any of the stakeholders, if you talk to the gatekeepers, if you talk to the third parties, if you go to conferences, I mean, you will see very clearly that, people do not make difference between comp and connect. I mean, we participate to the meetings, we do all the analysis, we really discuss all the things as one single team. Nobody really cares that much from which DG you come and what you may be doing when you're not doing the DMA, which is probably 99.99% of your time. At least most of the colleagues, will work on the DMA. When you ask about, the daily routine, first of all, I don't think anybody has one 8-hour daily routine. I think it's probably much more, but I think most of the people are actually excited about it. It's a very interesting, it's a new project. I think it's something which is novel, but which also has objectives which many can, which most of the people working on it or all of the people working can really subscribe to and feel very strong about it, And, it's a highly motivated team, which is, really a pleasure to work in. I mean, really, everyone is very much behind the objectives which we are pursuing here with the DMA, and there is an excellent level of cooperation, I have to say. So really, it is I mean, you're also talking to someone that is okay, now formally in DG Connect, but I came from DG Comp. For me, and for many of the colleagues, because we share similar experience. I think everything is very seamless, and you don't see this clear division or any division. You would say this is DG Connect and this is DG Com, or DG Connect covers this part of the DMA, and DG Com covers that part of the DMA. So I would say, and again, you see that on a daily basis, and I'm sure people will confirm that.
And we embarked this is election year. We know, and it's a very new regime, which is non-axiomatic, non-formulaic, and unlike ex post competition law, and thus allows you or anticipates a lot of or some discretion, some vision rather than box ticking endeavor. And thus, I wonder what in your view what is the role of political leadership in shaping the trajectory in which the DMA will be enforced in the future? Do you have, as admin team or the public servants, do you have sufficient resilience or responsiveness, on the contrary, to the views of political authorities who are and who will be directing both the directorate generals in the future?
I mean, one thing, and this again comes back to the very beginnings of the DMA, right? I mean, as we know, the final decision on anything related to the DMA or DSA, is the decision of the College of Commissioners, right? I mean, and of course, what was clear political commitment from the President von der Leyen from the beginning. If you think about, her her priorities at the beginning of her mandate, she made it very clear what, when it comes to the online platform economy, are the issues which need to be effectively addressed, right? So when you think about, the political steer, the political side of the discussion, I think there is a very strong commitment on the political side that we we need to deliver because there are issues that we need to effectively address. And this goes on the DSA. I mean, again, you have seen certain developments recently. I mean, many issues which are being which are being very actively investigated by colleagues. First case which has been formally open, and it's the same on the DMA side, right? I mean, yes, not much is seen, publicly in terms of, there was designation on 5th of September. Of course, there are some ongoing market investigations, and there is the 7th of March deadline of full compliance. There's a lot of work ongoing, during this period, so that when we come to the 7th of March, we can say, measures which are being, put in place by the gatekeepers, will ensure effective compliance, hopefully to a large extent. And this is what, end users and business users should benefit from. And, probably at that point in time, we will already be able to point to certain changes, both for end users and business users, and the choices that they will have. Like, for example, for me, an important objective of the DMA, is when we talk about the fairness, we very often, have in mind end users, but it's also about the empowerment, right? I mean, if you think about the digital environment, there are many, many things that we as end users were for a long time not fully aware, or, were not really paying a lot of attention. And many of the provisions in the DMA aim to ensure that, aim to empower users to take that back, to take the control back and decide for themselves, okay, I want to use that service, but under my conditions, right? Yes, I may still consent, and you may still, use all my personal data about everything that I do online when I'm using your services. But maybe I decide, no, I don't want that. I want to use your data, but I'm willing to accept, different, how do you say, service in a way so that I'm not being heavily tracked or profiled, right? I mean, again, it's a choice for the user, Same, for example, when we think about, third-party app stores or third-party apps, right? It's a choice. It's not something which is imposed on the users, but we want to empower the user, to have that choice. And if they want, they can use it. And which will, if you think about the other side, simply facilitate the contestability, because, more you will use that choice, and have that choice, that's also very important, more you will have contestability and choice and, innovation on the market. And, this is where, what is kind of driving us on a daily basis when you ask me about the 8 hour, what we do, this is what we want to achieve at the end of the day,
Final question. I know that this work becomes really a dream job for many, and you have taken over several academics already. What would be your recommendation? What is the kind of job description, open and less explicit elements of the profile, which in your view would be employable, and maybe more generally recommendation to those who just embarking on this really exciting journey?
I mean, one thing that we always say in the team is, we need any profile. Of course, you can imagine you will have quite few lawyers, you will have quite a bit of economists. We have increasingly more and more people with a technical profile, like engineers, data scientists, because there are many, many things in the DMA, that, touch upon security, integrity of the systems. We also have data protection experts that worked, in the European Data Protection Board before, so people that are really experts in their areas, right? But which is not to say that in order to how do you say that, to join the DMA team, you need to have 15 years of experience and be, the leading expert in your field. I mean, the great part of the DMA team, I have to say, is, the divergence in terms of both, the profiles we have, in terms of the background, but also, at what stage of our careers we are, right? I mean, so you know, if you think about the team, you know, we have very young colleagues, which actually are very, very good and very capable, irrespective of the fact that they don't have 15 years of experience. And on the other side, you know, you have colleagues which are a bit more experienced, which already come with certain expertise in very specific areas, either from the academic background, because we also have many of those, or, you know, from more private practice, or even, you know, some companies, right? So, I mean, frankly, if people are interested, you know, we are always interested in very, very good colleagues, very highly motivated. And I mean, what we can for sure promise, but I think you already sold that very well. You know, it's very exciting times. It's a very interesting area of work, something which is very dynamic. So, you know, we are only at the beginning of this journey, and, you know, things will be happening, I would say, on the regulatory side, the regulatory slash legislative side, but also on, you know, investigation enforcement side. So, I mean, never boring in this area, I'm sure.
Denis Sparas, thank you very much indeed for this fascinating conversation.
Thank you.